Hi, welcome. My name is Pete Calabrese. I'm the CEO of CanAm Investor Services. CanAm Investor Services is the wholly owned broker-dealer affiliate of CanAm Enterprises, one of the largest and certainly most successful regional centers in the history of the EB-5 program. It's a great pleasure today being joined by Mr. Christian Triantaphyllis, partner at Jackson Walker, AILA EB-5 committee member, and IIUSA Board of Directors member. Christian has joined us today in our offices here on Wall Street in New York City, and we're very happy to have him. We've gotten so used to these Zoom interactions and all this, so when Christian was in town for the day, we had to make sure we took advantage of it and had him in. So Christian, welcome.
Yeah, thank you, Pete. Happy to be here in person. Lovely offices here at CanAm, and happy to talk about EB-5 with you.
Fantastic. So today we're going to talk a little bit about adjudication trends, processing trends in EB-5, and offer some practical tips for investors who are looking to move forward to be able to give you a good roadmap as to have the best possible pathway towards getting your EB-5 approved and completed. So I guess starting off, Christian, I think what would be helpful is to maybe talk a little bit about some of the processing trends or maybe some of the processing timelines that we've been seeing for our investors and your investors that are making their first petition, i.e. their I-526 petition, and maybe the differences that they're seeing between investing in a high unemployment area project as well as a rural area project, which has that additional benefit of priority processing.
Sure, happy to. So when thinking about processing times, we have to think about two sets of petitions. So we all know that the I-956F application needs to be filed in order for the investors to then file their I-526E petition. The I-526E petition will be approved only after the I-956F application is approved. So one of the first timelines we want to look at is how long is it taking the I-956F application to get approved by USCIS. So there were some recent reports on general timeframes for these I-956F applications. So I-956Fs filed in connections with rural projects were being processed in about 10 or 11 months. I would say from my own practice, I'm seeing a similar adjudication time. Sometimes shorter. I've seen as quickly as 4 to 5 months. I've seen a bit longer for rural projects at 13 to 14 months. But the other type of project we file these I-956F applications often for are high unemployment urban area projects. So typically you might see a little longer of a time frame, 12 to 15 months, for the approval of the I-956F. So we've got that time frame taken care of. Now we look at how long will it take the I-526E petition to get approved. The reports were that it was around 10 months for those investing in rural projects and around 15 months for those investing in high unemployment urban area projects. I think trends I've seen more recently, because I don't know how delayed those reports are, I think I'm pretty often seeing investors who are investing in rural projects getting approvals in around 12 months, and investors who are investing in high unemployment urban area projects getting approvals in around anywhere from like 18 to 26 months or so, pretty consistently now. So there is, priority processing is a real thing. It's certainly working in EB-5 for those investing in rural projects. But those investing in high unemployment urban area projects are not that far behind. And of course, these processing times can vary on a case-by-case basis.
Mm-hmm. Yeah, no, I agree. And that is in general what we're seeing as well.
Good.
There are more rapid adjudications for some in both categories. There are longer adjudications, maybe some outliers in these. But I think that the overall trend is that priority processing, while undefined, certainly does just mean faster.
Yeah.
And I think that's the best that you can say about it. And I'd say by faster, what does that mean? I would say 5 to 6 months is generally a good understanding or a good estimate of what that time frame would be. One thing that is always worth noting is that these are the 956F petition approval and the I-526E petition approval. They are two separate approvals that need to be done, but they can be pending at the same time.
That's right. That's a very big point. I'm asked that often. Even though the I-956F application is still processing, not yet approved, can I file my I-526E petition as an EB-5 investor? Yes, you can. Just work with your immigration attorney on the timing of that. Coordination with CanAm, we'll get that filing done in the proper way.
Mm-hmm. Yep, so the 956F gets filed, And then that allows for I-526Es in conjunction to be filed.
And if we want to
the
get
I-526F gets approved, and then the I-526Es can get approved. They can go at the same time. Those timeframes that we talked about for the 956Fs and the I-526Es are both correct, but sometimes you want to make sure that you're not thinking of like one in addition to the other.
That's right.
So those can be going at the same time. So Christian, maybe if you want to talk about maybe some of the notices or some of the feedback that you've been getting from USCIS on these I-526 petitions that you're filing.
Yeah, happy to. I mean, I think what I'm seeing is probably, I know that others are seeing this as well, so I thought it would be helpful to clear up some of these oddities or issues or errors that we're seeing from USCIS's side. These are kind of processing related errors or issues that are arising, and there are little things that you can do as little solutions here and there to try to address some of the issues that are coming up. So for the longest time we were having a problem with I-526E receipt numbers, the number on the receipt notice, not registering on the USCIS case status website. That was quite frustrating for clients because the minute you file, they want to start tracking the status of their case. And the best way to do that is by plugging in the receipt number on the USCIS website. And if it comes up as an error, the first reaction is, uh-oh, there's something wrong with my filing.
Of course.
But we know that there's nothing wrong with the filing. The receipt notice has the receipt number that's the correct number. If we were to contact USCIS through their IPO email address, USCIS recognizes that receipt number. This was a data entry issue. There was a lag on USCIS's part in terms of issuing the receipt number and then putting it into their own system so that you could then get it registered when you log in, when you put that number into the USCIS case status website. There's been a lot of interaction, especially through the AILA EB-5 committee, to try to get USCIS to speed up their data entry and address this issue. One of the main reasons that we needed USCIS to address this sooner rather than later is because we were also starting to see improper rejections of adjustment of status applications for those who were filing the I-526E petition and also filing the adjustment of status application. The rejection was coming back saying, we don't see an immigrant petition, an I-526E petition, on file for us to connect this adjustment of status application to.
What are we adjusting to?
So what are we adjusting based off of? And that's because of that data entry lag. So we really needed USCIS to get that right because we cannot, rejected AOS applications can cause problems, and we need to make sure that they stick, and it can't be because of a data entry lag time. So we are starting to see more often than not that the receipt number is registering on the USCIS website. I hope you've felt that same trend to come to fruition.
Yeah.
We saw that there was a few months ago a significant number of my clients contacted me saying, hey, not only can I now see that my number registers on the website, but there's a status saying that my case is being actively reviewed. What does this mean? Am I about to receive an approval?
Right.
And this is for people who had filed over a year ago and for people who had filed 2 months ago. So it was all at the same time, them getting this, oh, my number registers and now my case is being actively reviewed. It was my assessment that this was USCIS's status saying your number is now registered on USCIS case status website and we have your case.
Right.
It did not result in adjudications within a few days or even a few weeks. Now, those cases have since been adjudicated, which is great to see, but I just thought it would be helpful to make it clear that that actively reviewing update, I think, is USCIS's way of saying, we have your case, your receipt number registers with us, and we're working on it.
Just hugely helpful, because all these things, and we talk about people, and this is all a bit of a management of expectations, which is really the impetus for this conversation from the get-go.
Right.
Because the last thing that you want is for someone to call you 2 months after they filed the petition, say, am I getting approved? And have I gotten? And I heard that someone else I saw on LinkedIn and someone else just got their approval, and that's great for them. And there are outliers, but this is what a more reasonable expectation would be. Similarly, when you start to get some sort of feedback from USCIS, you start to think any feedback means it's a good thing and that we're getting close. It is a good thing in that you are in the caseload and you have, but you could potentially be seeing an actively reviewing notice on your file for months.
Correct. And you said it, the way I think about it often is maintaining reasonable expectations. You know, USCIS updates do not mean that we shouldn't continue to maintain reasonable expectations.
Right.
So that's just part of, you know, the information sharing we're doing now,
Absolutely.
and then the daily, my daily practice in interacting with my clients to make sure that they're getting a good idea of what USCIS is communicating.
And so one of the things I think you had brought up to me too, you said that you've seen some instances of USCIS potentially losing exhibits from the EB-526.
So this has actually happened more recently for clients that I filed pre-RIA and post-RIA. I kind of understood, I was a little more understanding of the pre-RIA filings because they've had them for quite some time. They could be shuffling around you know, packages from one office to the next, but the post-RIA, you know, those have not been processing that long. So the way USCIS has communicated about this is in the form of a request for clarification. They're almost giving us a heads up, hey, we're having trouble putting together your whole file. Before we issue a formal request for evidence, do you want to send us exhibits 7 through 12? Sometimes that can be almost the entire set of source of funds. Or perhaps it's just a certain section of the source of funds. But really, that's an easy way to respond to USCIS. But I just also wanted to mention that because if they're issuing that request for clarification, it does not mean that the initial I-526E petition didn't include those exhibits. I think it's on the USCIS side. I've heard other immigration attorneys reporting similar. So just putting that information out there, and there's a pretty simple way to address it by just responding to that request for clarification, and then USCIS can make their decision on the case.
Okay. Is that generally a good indication, though, that they are starting to review the case and that this could be something that is leading to a more rapid adjudication, or is there still the potential for, you know, some time frame while they're still reviewing the case?
Yeah, I think it's actually a good indication that they're working on the case and you should see an outcome soon. I'm not saying that you should see an outcome in 1 to 2 weeks later after replying. I guess it would depend on the level of the documentation needed in the request for clarification, the RFC. If it's essentially the whole set of documents, you know, you might want to wait another month before checking up on the case. But if it's just 1 or 2 exhibits, you may get an outcome in the near, you know, 7 to 10 days after responding. So I do think it means they're actively working on the case. An officer's reviewing it, and hopefully you'll see an outcome soon.
Awesome. So to kind of maybe take a shift to the next step in a lot of this process, because you've seen it, we've seen it, I mean, so many of the clients that we have together, but just the clients that we have in general. But there's been a big shift of where a lot of the investors who are coming into our projects are coming from. Bear said what their actual country location is rather than say what country they're born in. So the RIA passed in 2022 brought along with it the ability to concurrently file. We've talked about this a ton. So the concurrent filing of adjustment of status is a huge upgrade for a lot of these investors who are here already on different visa categories, and they are looking to move forward with that adjustment of status. Specifically, I would say for Indian investors, and there was actually data at the IIUSA conference that backed this up, that a majority of the investors who are filing coming from India are concurrently filing for an adjustment of status, whether they're H-1Bs who are doing so or potentially F-1s. I would say, I think that what they call the IIUSA, and this was a small segment from just one of the banks that was participating, but upwards of 75%, which I think is in line with what we would be seeing as well. A larger majority.
I think it was especially for Indian nationals.
Especially for Indian nationals. There is a higher number of concurrent filings in general, but especially for Indian nationals coming in. So do you have a sense from your client base as to what the timing is potentially of that 485 petition approval, what they could potentially expect from that, because I think sometimes what can get lost in people's expectation is that my I-526 is done, now I have my green card.
That's right.
And they're in the right territory.
Sorry, that's a misunderstanding.
Misunderstanding is that there's still some important steps, whether it's going to the consulate or whether it's getting their adjustment of status completed. So I think that for the sake of this conversation, maybe we just talk a little bit more about the I-485 and maybe some of the times that you're seeing, the timelines that you're seeing from them, as well as maybe some of the feedback that you're getting at that stage from USCIS.
Sure. So just to build on that, whenever speaking with a potential client or having follow-up discussions with clients, I try to say again and again, this is a multi-step process to get the conditional green card. Yes, we could concurrently file the adjustment of status application at the same time as the I-526E petition for those in the US with a current priority date. But once the I-526E is approved, when will the conditional green card be approved? Well, we have to look at when will the adjustment of status application, the I-485, be approved. That's the big question. So I typically say perhaps another 6 months after the I-526E petition's approved, you'll see the issuance or the approval of the 485. That's just a good kind of baseline expectation. I have seen earlier, I've seen dramatically fast, as quickly as 2 to 3 weeks after approval of the I-526E. I've seen 3 months, 4 months, but I've also seen longer, and I mean much longer, 12 to 24 months after approval of the I-526E petition. And it's not as easy to interact with the California Service Center that's adjudicating the adjustment of status as I think it is as easy to interact with the IPO through their email address. It's hard to get updates. Others go to writ of mandamus filings to force the issue by suing the government to act on the 485. But it's a really wide-ranging processing time for that 485. I'm still set on giving a baseline expectation of around 6 months. I've seen it consistently enough, but it doesn't mean it's happening across the board.
Yeah, good, which is really important information because your I-485 filing brings with it its own benefits that go. I mean, you have the ability to have your advanced parole, you have the ability to have your EAD, and those are benefits that are independent of your I-526 petition approval. You should likely have those. Sorry, go ahead.
Oh yeah, well, I want to make sure we're clear about that, but you were saying you should likely have those in a certain time frame? Yes.
Yeah.
Typically, I'm seeing around 3 to 7 months after date of filing the entire AOS package, so that's really good. So even if it takes another 4 or 5 months for the I-526E approval and then another 6 to 9 months for approval of the 485, you've got those interim benefits in the meantime. But to build on that, I'm talking about timeframes when priority dates are current. I'm not talking about, nor really here, giving estimations on how long it will take due to upcoming EB-5 visa backlogs, perhaps later or this year or next year. But you reminded me of how important, how valuable those interim benefits are, because if it starts to take 3, 4, 5 years for that adjustment of status application to be approved, you will have that employment authorization document, that advanced parole travel permit to use in the meantime, which is kind of like going on and living your life as you need to while waiting on the issuance of the conditional green card.
Yeah, no, it's a huge, huge benefit. And when we talk about it all the time, when we talk about the benefits of concurrent filing, but it is also an important distinction to know that that adjustment of status needs to also be approved, not on top of the I-526. And your time frame of that is very, very helpful. Maybe trying to shift gears a little bit more to maybe talk about some of the, let's say, complications that come from projects, but even the most well thought out, the best put together petition could bring with it a request for evidence.
Sure.
And those requests for evidence, we have a good attorney, you're going to answer it, and you're still getting approvals from those. Those are coming through. But I think what might be helpful is to maybe talk a little bit about some of the RFPs that you've been receiving, how you've been able to maneuver your way through those and accurately assist USCIS in completing this, and then maybe leading it towards some steps that someone who hasn't yet filed for an I-526 could take to allow themselves to have a more comfortable and straightforward process in completing all this.
Yeah, I can get into that. So RFEs, I think for post-RIA investors have been pretty reasonable. I think the more difficult RFEs that we've seen recently are for those filing before the RIA. Although, let's be mindful of what we have seen. So I think USCIS is obviously still very heavily looking at linking of funds prior to making the EB-5 investment. What I mean by that is you've done a great job of talking about the source of the money. It's very clear this is the person's professional background. They've been working in it for a certain company over the last 25 years. But then it gets to the path of the funds. How are the funds making their way to the EB-5 project's escrow account? And if there are sort of a lack of clarity on how those funds have moved to the U.S. or within the U.S. to the escrow account, USCIS is typically going to be asking questions about that. So bank statements showing the remittance of funds are very important. I oftentimes will get from clients a screenshot that doesn't have enough information on it. They just want to file, and I'm reminding them that we've got to have the full bank statement, or if it's going to be a screenshot, it needs to have the name of the account holder, at least the last 4 digits or so of the account number, the name of the bank on it as well, and that's what USCIS is going to be more comfortable with in terms of tracking the movement of the money. Another concept that I've seen come up is earned income over the years. Tax returns don't always tell the full story. There are some countries around the world that don't require tax returns, and so we really have to dig deeper in terms of demonstrating what someone's annual salary or compensation has been from their employer over the years. Bank statements help because you can go through sort of a line item, sort of marking out line by line where those deposits are coming from and showing that it's linking to their employer. But we do work with clients on drafting employer verification letters where we're trying to put in more detail about the salary earned, bonuses earned, stock options given. But USCIS doesn't want any old employee signing that letter. They want somebody who they feel would actually have access to the books and to the HR records, demonstrating what that employee would have received over the years. So I've found them to be more and more particular about who's signing off on how much someone has been making over the last 5 years. Kind of a more realistic, CFO, accountant, HR manager type of position. Mm-hmm. I have to get into partial investment in terms of RFEs because this is just such a hot topic, a common way to move forward with EB-5 right now. And what I mean by partial investment is we all know that the required investment for investing in a TEA project is $800,000. But investors who want to get started in their immigration process sooner than that
might get their priority dates squared away.
That's
they
right.
want to try and have their place in line a little bit further ahead.
Get their employment authorization document going, start working elsewhere. They have, let's say, $400,000 now, and they're putting together or they're working on sourcing their remaining $400,000. We go ahead and file the I-526E petition. What we do is we try to document the full source of funds on all of the money. That doesn't mean I have those documents in hand, but we want to explain to USCIS as clearly as possible where these funds are coming from. We also want to make sure that our client sticks to that story. We're trying not to deviate later on if it's going to be the remainder of the money is coming from the sale of a property. Instead, 4 or 5 months later, the client comes to us and says, I'm actually taking it as a personal loan from a friend. That causes some potential complications to the I-526E petition. So another thing that happens is we do try to interfile. We update the file with USCIS once we have the full investment made with the remaining funds documented. USCIS does not always put together or put that package updated into the file. They will still issue a request for evidence from time to time saying, it doesn't look like if the full investment has been made, show us how you at all qualify for this program. And so, clients get a little bit concerned, have we actually been working on the file? Have we updated USCIS? Yes, we have. And I'd say 9 times out of 10, that goes flawlessly and USCIS doesn't ask any questions. But they still are capable of coming back. We don't see the updated files. And we explain to them, hey, we did submit these, and here's the documentation once again. There are other times where USCIS acts fast enough so that the funds have not yet been invested on time. And that's really where we have to work closely with our client, show that they're on time with your schedule, okay, so they're still compliant with you. It's not like they've been missing your deadline on when you want them to complete the funds. And then still we want to show that they make the investment, we've documented the source of funds, and that's how we'll respond to the RFE.
Right. No, which makes perfect sense, right? Because it's perfectly lawful to be able to file your petition while in the process of investing. Now, the ability to partially fund and move forward with the project is subject to the different parameters of the regional center that you work with. You know, we have our own guidelines for these, others have their own. Generally speaking, it's a pretty tight timeline, and for us it's more of a logistical concern of letting the people compile and have those funds ready. Some Christian will file the petition, he'll go ahead and they'll be able to move forward with it. But you know, like we talk about some of those outlier cases, and we call that a good thing when the outlier case is that your petition is moving forward quicker than expected. Sometimes you can have that unexpected consequence of those two schedules not pairing up with each other. If your regional center has provided you with further flexibility in your funding schedule and USCIS has moved forward with moving on a petition, that is a potential risk which would lead to an RFE.
That's right.
And would lead to obviously action on the investor's part to make sure that they are able to move forward. It can be the unfortunate outcome of some good news that doesn't work in with the best laid plan that was put in place.
I do have one other kind of practice pointer. I think USCIS is becoming more and more interested in lots of different deposits in bank accounts that may not have anything to do with the EB-5 investment. So I'm thinking of the student in the US who's receiving a gift from a family member to make their EB-5 investment. I would say that when looking at what kind of bank account you're going to receive that money into, the less active that bank account, the better right now. Because I think USCIS is picking on deposits, bringing up issues that are really should be non-issues or non-factors in the source of funds. If you're willing to open up a new bank account, you've got a bank that will work with you on that, I would say do it. And you can just show this is the only money that's hit this bank account is my gift, and then I turned around and used that for my EB-5 investment. If you're not going to open up a new bank account, I will say most of my clients do not. They just use the bank accounts that they have. I would say slow down on your activity in that account. If there are any large deposits, make sure that from the time that you receive the gift or the funds that you're going to be using for EB-5, that the money did not dip below the qualifying invested amount. Other deposits came in subsequent to that, and you're still saying that the full investment is coming from that gift. Well, USCIS could come back and say, well, we think that while you got an $800,000 gift, it dipped down to $700,000 and other deposits came in over the next month. You then made your $800,000 investment. We come up with that kind of issue with our clients all the time. Bring it up, clients get a little bit, I don't want to say frustrated, but start to question this whole process. We say, no, look, let's just document this. We can, really make this airtight in the filing, and then we file, and USCI should be comfortable with that.
Awesome. No, very, very helpful. Because I think that this is all of these things tie in together in that the goal, the expected outcome is to reach this endpoint of getting your full immigration and to get your repayment of funds. And all of these steps are very practical ones in getting it, both in having a good idea of what the timeline is going to be to accomplish these, what some of the obstacles and what might be getting looked at by USCIS a little bit more closely in this process, and then how you can maneuver your way through, maneuver isn't the right word, how you can complete this suitably to make sure that all of these things ultimately get you to that spot you're looking for. So I think we touched upon a lot of these, and we definitely went through the steps, but maybe Christian, just as a quick recap of some of those, the tips that you would have or the steps that you would have for someone who's listening to this, who's going to file an I-526, the steps that they can take to make sure that they can have as smooth of a process as possible. Because we talk about all the time, right? Prior planning.
Yeah.
Have the plan in place, have the, your schedule set up. I mean, it's the old, measure twice, cut once adage.
Absolutely.
So maybe if you could just summarize that, to try to give someone that there some good tips in filing their new I-526.
Okay, so I will lead with, do not start moving money before speaking with an immigration attorney who you want to work with on your source of funds. Wait for your immigration attorney to understand where your funds are going to come from, and then speak with that attorney about how those funds will make it to the EB-5 project's escrow account. So that's my first tip. Second, if you want to start planning ahead of time, start thinking about documents that might help show how those sources were accumulated over time for the funding that you're going to use for EB-5. Start thinking about kind of old tax documents for the last 7 years, to be specific. Start thinking about access to bank statements where you know that you received large deposits, distributions, bonuses. Think about whether that bank is available to answer those kinds of questions. Think about current or previous employers. What do you think their willingness would be to work with you on document requests? And just think about liquidity. Do you have your money in mutual funds and in investments? If so, start identifying which of those might be more liquid than others, which ones you are more willing to part with in terms of your investment than others, and start to plan on when you'll liquidate those funds. But don't do it yet. First, work with your immigration attorney. Make sure it's something that you can demonstrate how you made that investment in the first place, and then you can time it all out with your attorney and your project and make your EB-5 investment.
I think that was fantastically said. I mean, we say it all the time when someone's coming in and they'll start to talk to us, and we always say, yes, I think that the best thing that someone can do that's coming in is to identify their immigration attorney and to identify their regional center. Before they start to get too far into projects, before you start to get too far into the details, understand where you are, making sure that EB-5 is suitable for you, making sure that you have those things set forward to be able to move forward at a rapid pace, if that is what your hope is to do, and that you feel comfortable with the regional center operator, with their platform, because generally speaking, a good regional center like CanAm, you're going to have good projects. And that's going to be your basis for going ahead and moving forward. Just like when you work with a great immigration attorney, they're going to do great immigration work for you, and they're going to cover all of these potential pitfalls that might be coming up as you're going through the process. So, I think that this was a very helpful, hopefully informational session for people. I think that we went over some pretty good practical tips here. Obviously, if you have any other more specific questions, please reach out to me, please reach out to Christian. And we're happy to go through either side of these to help you with your EB-5 investment. Thank you.
Thank you very much.